I'm going to place mine. I apologize. May I place mine in as, I don't even know how to identify it, and that is Mr. Millard. So it would be Texas EquiSearch 1.
Your
Yes, sir.
composite exhibit 1?
Yes, sir.
That's fine. Let's go ahead and mark it then. And Mr. Byers, you want these back?
Yes, please.
All right, that's fine. Look here, and I have the other items that you handed me. Were those for my review here, or do you want those
You
back?
can keep those. Those are actual
All
copies.
right. Okay. As soon as I review these, I'll write an order. Hopefully today, worst case scenario, tomorrow or Wednesday.
Judge, may I interject?
Yeah.
Mr. Baez made an argument that was abandoned at the hearing last August, that Texas EquiSearch was an agent of the state. I don't know if the court recalls at that time. We had several witnesses here in an effort to rebut that argument. If they had chosen to make it at the initial argument on these issues, they waived that argument, indicated that they were not going to proceed with the position that Texas EquiSearch was an agent of the state. If the court is considering that as part of its order, we would like an opportunity to address that, stating first that the assertion that Texas EquiSearch is an agent of the state is not the same as presenting evidence that is in fact the case.
Mr. Baez, I don't disagree with you. I vaguely remember this coming up previously, not to the extent you do, obviously. But if it becomes an issue, I'll send out an email and I'll ask for something else. Okay?
The other thing that I wanted to advise the court of, I have reviewed all of the documents in possession of Mr. Nejame on behalf of Texas EquiSearch. The Orange County Sheriff's Office went out to Texas and reviewed these documents. Certainly, if we found anything in there, we would have alerted Mr. Nejame to that fact, and I'm sure he would have cooperated in providing that document as part of this discovery process. Mr. Baez additionally has received documents from Texas EquiSearch that were filtered through the Orange County Sheriff's Office. I spent about 6 hours over the course of 2 separate days at Mr. Nejame's office. It is not difficult when you look at these documents, if you know what you're looking for, to understand them, to indicate on there which pages you might be interested in. I believe I even tabbed some information for Mr. Nejame that ultimately was in that original package that went to Mr. Baez in October. There's no need for the court to have a whole-scale an order that we need to subpoena these documents from Texas EquiSearch and then turn them over in discovery. We're not an agent of the state, of the Orange County Sheriff, or anything of the kind. The documents that were relevant have been released. Obviously, we have no problem if Mr. Baez or someone on that team wants to spend the 6, 7, 8, 9, 10 hours at Mr. Nejame's office that I spent looking at these documents. It's not a mystery as to what's on them and what area these people search. They have attached maps with them. They have notes with them. In fact, the one that he has from Mr. Jordan does have a map that Mr. Jordan himself, according to the statement he gave to my office that's been provided in discovery, marked on. So if he would just go there, and I know this argument's already been made, but I'm also, from a different perspective, trying to advise the court. This isn't a difficult process. Everything he needs is there if, in fact, they take that opportunity.
I'd just like to briefly respond, Judge. First of all, we've never abandoned our position that Texas EquiSearch isn't an agent of the state. I don't see how they can stand here with a straight face and argue that.
Then hold on. Can you get a transcript of that from the hearing?
I suppose I can.
I have a vague memory of it, but I cannot.
It was the same day Mr. Macaluso was here explaining to the court that they apparently uncovered all of these people that we've still not received a witness about.
I remember the day, but
it was August 21st.
If there was a waiver on the record, I'd like to get a copy.
Little did we know that they did have information that Kaylee's remains were placed there afterwards, and they failed to turn it over to the defense.
Okay.
He's just wrong.
Your Honor, may I have an affidavit? May I approach?
Yeah, that's fine, but we once again morphed into a different issue. I understand the issues set for today. I'll read this and I'll...
This addresses the issue, so that's an affidavit that's submitted previously to refresh everybody's memory. as it relates to Texas EquiSearch and the agency issue, Your Honor.
The other point that briefly that I would want to make is at this point, as it relates to the defense claim that they are an agent of the state, there's a failure of proof at this juncture. And if, in fact, they do want to reset that matter for hearing, we'll be able to rebut that easily.
Okay, yeah, 60 seconds.
Well, to finally conclude on the inspection of these documents, they don't know what we're looking for, neither does the state know what we're looking for. To sit there to say, well, you can easily inspect these documents, it takes it, if they want to take 6 hours out of the day, how do they know how long we're going to take? How do they know how much information we have? How do they know what direction we're going in? They don't.
Place a time limit on it.
They don't. The problem is, Judge, is we don't have access to these documents. If we can't write anything down, we can't actually make copies of anything here. We're supposed to go in there with a photographic memory and automatically look at a document, 4,000 searchers, and say, okay, we need page 737, 241, 1,367. It's to the point where it's almost ridiculous.
I understand the arguments. All right, thank you all. I'll get right on.
There was another motion that the state has agreed to hear today. If you still have
That
time.
was filed this morning.
Yeah, both parties agreed that
But
it's time.
it arrived this morning, and I haven't even read it.
That's when I got it at 9 o'clock this morning.
Yeah.
I had talked to
Is there an agreement on it?
There cannot be an agreement on it.
I don't even have it here in front of me. What's the? I mean, how long?
They're
is it?
asking for the statement that was surreptitiously recorded that Mr. Jordan made that I had previously moved for a protective order because to release it or to listen to it was a third-degree felony. Then the court granted that motion for protective order, and the statement of Mr. Jordan has not been released in discovery. I've never even listened to it because the court ordered us not to. It's a felony for me to provide it to the defense, and they are seeking, I guess, court protection from us.
Hang on. The motion is here. Can we argue this in 5 minutes?
We can certainly give it a run, Your Honor.
Well, it's in the court file along with a sworn statement. You have no problem with it?
No
Yeah, I got
problem
it this
with-
morning, so I didn't bother reading it.
No, I understand the issues. I have a problem with just having the court grant it because then you're giving us permission to commit felonies.
All right, quickly, go ahead.
Your Honor, the statement that it's an issue was one that was made by Mr. Jordan in the presence of his counsel at the time and our lead investigator. He apparently recorded it surreptitiously. Neither the lawyer nor our investigator have complained, in fact have advised they waive any objections to the publication of it. 934 is a statute that deals with protecting rights, reasonable rights and expectation of privacy, and does make certain surreptitious recordings a felony, but not all. By any means, not all. I will give you a copy. I know you won't spend a lot of time. Linda, do you have any? I'm sorry. Where did you have this, Your Honor, please?
You didn't cite it, and I do not have it.
You want that?
This is 934.
Yeah.
He has a case
Florida-
citation.
Florida Supreme Court decision, Your Honor, at 473 Southern 2nd, 1272. And the state versus Inciarano, INCIARRANO. It's a decision of the Florida Supreme Court standing. There are distinguishing facts, but basically for the proposition that not every surreptitious recording is entitled to an expectation of privacy. And that was in a murder case that actually I remember it happened on Virginia Drive here, 25 years ago. It's very clear that not all of them are doing that. But here's the situation. No victim wants prosecution, and they have said they don't want any problem. Release the tape. I understand the prosecution's position. They're thinking that because the statute says that the use of such a recording can be classified as a felony, and there are prohibitions against the use of it. The way around this is in seeking the. And here's the reason for it, of why this tape recording is important. At that, as you now know from Mr. Byers' presentation, Mr. Jordan sent an email to the lead investigators back in December of '08, saying he was the team leader, he searched the area, the remains had to be put there later. That's his opinion. He was the team leader for Equus. I don't know what happened or didn't happen. Ultimately, that'd be a jury question. That's a significant jury question for all the reasons you've already heard. Then he, without us knowing, he's investigated, and he gives a statement to our investigator in the presence of his counsel, effectively the same thing. Thereafter, he's interviewed and apparently changes what he had to say. That tape recording of the interview, of his tone of voice, his response with his lawyer sitting there, should be very critical, one, to the defense in defending against a claim of recent fabrication, if there is one, and two, corroborating what he had to say before, as well as, or impeaching a change of testimony if it comes in later that he's been woodshedded about worrying about him committing a felony and so forth. And it's not unusual that the court has a right to get involved in these situations, Your Honor, and there's some other case law I can provide very quickly.
You can submit it. Let me hear from Ms. Trent.
Okay.
Your Honor, in my motion for protective order, I did indicate that this would be a statement that would be otherwise discoverable, and under other circumstances, we certainly would provide it. However, unless the defense can provide some authority for the fact that the release of this tape is not a crime, a felony crime, then we believe that the court is without the ability to order us to provide it. As I had indicated initially, we have not listened to it. We don't intend to use it. Mr. Mason had an investigator, or at least Mr. Baez, had an investigator that was present that could testify as to his recollection of the conversation. So there are alternate means to impeach Mr. Jordan if that comes up.
When did you file your protective order? I'm trying to find it. Or do you have a copy of it?
I do, if you want, if I may approach. My motion was filed December 9th. The court order is dated December 16th.
So you're saying absent some guarantee that you're not going to be hit with a felony charge?
It's called use immunity. They have discretion to do. They can immunize each other. You can order them to do it as a matter of law. You can order to say to immunize.
I disagree with him. I disagree with him on that point. But it's also a felony.
One at a time. One at a time. Go ahead.
It's also a felony for Mr. Baez or Mr. Mason or anyone else who comes into possession of this recording to use it, to disseminate it in any fashion, and that's simply statutory language. The issue of whether or not Mr. Jordan is going to be prosecuted for it or that the quote-unquote victims of the crime have declined prosecution is not relevant to the issue that's before the court, and that is whether or not anybody can use this tape for any purpose under the statute.
Okay.
In a death penalty case.
Well, that's...
All right, thank you. Any cases, anybody want to leave with me on that issue?
If I find one that actually supports their position, I will provide it to the court. I've not.
Okay. Thank you.
Actually, Judge, there was...
Wait a minute. Okay. Just for... Martin, if you'll come
Is this
without the court. I'll come back in and then we can make a record if necessary.
May I be excused, Your Honor?
Absolutely. Thanks. And again, counsel's not meeting with the court. They're going to talk with one another.
Thank you. Oh, what? Yeah, no, wait. Don't go.
Yeah. Eventually. Right now, it's fine. I'm not going to go out.
Well, she's coming in.
Is that okay?
Yeah.
You can just call it just so we don't need to come back in. Hold on. I've always wanted to say this. Where's adjourned? Oh, there he is. We don't need you.
Okay.
No, we're
Thank
good.
you, sir.